So let's start with the topic today. That is the first topic, that is sedition law. The first we'll see what is the context why this topic is in news. So recently the Supreme Court has directed all the law enforcing agency, that is majorly the administrations, center and all the central government and the state governments, that don't file any cases based on the given the penal provision that is mentioned in the Indian Penal Code, that is section 124A. So as we know, any text is divided into the number of articles or maybe sections. As we know, the Constitution is divided into number of articles. Likewise, any law in India, any law is also divided into different chapters or maybe different sections. So each section might be talking about the different, the different topics. So here, this is, the Indian Penal Code. The Indian Penal Code, as the name says, the penal means here it talks about the punishment part. So why punishment arises? Punishment arises that the law government or maybe the parliament or maybe the state legislatures which pass different laws, and in many of these laws which will ask the people to follow these laws clearly. If anybody violates these laws, so obviously the given the penal provision, that means punishment should also be mentioned. So what are the punishments is meted out to the different penal, different penalties or different law violations made by the people of the given country. So likewise, one of the penal provision that is mentioned in the Indian Penal Code is section 124A. So the section 124A talks about the something called as summary, that is sedition law. So the Supreme Court directed all the governments in the country that don't file any cases based on the given penal provision mentioned in the IPC. So then what is sedition law? The sedition law, as it is mentioned, as it is in the Indian Penal Code, it is mentioned in the quotation here. But if you see specifically that the more important thing is from here, the spoken or written or by signs or by visible representation. So it means that it is clearly talking about the human expressions. The human expressions, it can be in the form of speech or in the form of writing or in the form of through an art form. So expressions can be in any form. So it is, this section clearly talks about an individual's expression. And this expression, what kind of, the kind of expressions are penalized under this sedition law. This is something that if these expressions are creating something called as a hatred or maybe something contempt or excites or attempts to excite disaffection, right? And towards, it is specifically talking about the government. Okay. So there are two things: an individual have a right to oppose the state. State means the country, right? Does anybody can take a stand against the given country, their own country? That is first question. The second thing is the given individual, that means citizen of the given country, whether they have the right to oppose the given government. So government is different, the country is different. But with respect to opposing any individual or maybe citizen, opposing their own country is never accepted. Okay. But here this sedition law is talking about something opposition towards the government. So the government here, it is specifically talking about government established by law. Because in India, the government is established through a democratic process. The democratic process wherein people do participate in this democratic process and lawfully, as the procedure mentioned in the Constitution of India, the neutral body called as Election Commission will conduct the elections and will elect the member of parliamentarians or the member of legislatures for the given state government. So the party, based on the rules or the regulations mentioned in the Constitution, a government is elected. So the government that is elected by law, that if anybody through these, the written form or through any expression, if they create something called as a hatred or maybe exerts, an attempt to exert disaffection towards the government, these type of expressions are clearly labeled as sedition. Okay. So an individual, talks about individual can criticize the government. It doesn't say that don't criticize the government. You can criticize, but only thing is you cannot create hatred, in the other people, or maybe you cannot excite disaffection towards the government, right, which is majority based election of the elected government. So these people deliberately cannot create a disaffection in the society wherein large number of people will start opposing the government. Okay, so this is the specific provision or the the explanation about the specific sedition law. Then what is the origin, how this sedition law at all entered into the IPC as a penal provision? See, this is something, origin is related to the British colonial government, which was ruled the government, the India till 1947. So as IPC, as a penal code that is enacted in India in 1860s. Okay. So related to this, the 1860s, the Indian Penal Code was enacted, but in the original penal code, there was no this provision called as sedition law, that is 124A. But this was added later on in 1890, right? This particular provision as 124A. Okay. So why the British government at that point of time enacted this particular provision or added this sedition provision? This specific provision is enacted specifically to curb the dissent. Dissent means taking any stand against the elected government. So this political dissent to the curb the political dissent, which we can see the common phenomena during the independence movement, especially post 1857. There were many Indian people, those who are opposing the British government. Okay, so when anybody is creating this kind of disaffection towards the British government, they wanted to they book the people and sending them to jail. So this is something called a political dissent, and to specifically to suppress this political dissent, opposition to the British government, this specific provision was added. And what are the famous different famous personalities were booked under the sedition law? You can see the famous personalities that Balagangadhar Tilak, Annie Besant, right? The Muhammad Ali, Shaukat Ali, Maulana Abdul Kalam Azad, Mahatma Gandhi, even Jawaharlal Nehru, and even the Subhash Chandra Bose. The different famous personalities, those who were at the forefront of this independence movement, many of them were booked under this sedition law, especially post the 1900. Okay, so this, but the logic that we see that the sedition law added by the colonial government, wherein they see that this is as an offense towards their government, that is logically understood, because that is not a popularly elected government. This is a colonial government, that is other countries people are ruling the Indian countries people. So any they cannot they are not in a position to accept any kind of opposition to their ruling. So that the logic that we can understand for the adding of the sedition law. So when you can see that Indian, the people were booked for just merely opposing the colonial government under the sedition law. What is the the constitution rule? The constitution makers did when the constitutional discussions were happening post 1947 at the framing of the constitution. The first and foremost thing, what the constitution talks about with respect to the freedom of speech and expression. Freedom of speech and expression is one of the fundamental rights. The fundamental rights, as we know in the constitution, it is mentioned in the part 3. So in the part 3, one of the constitution, one of the provision, the fundamental right is Article 19(1)(a). It talks about the right to freedom of speech and expression. So the right to freedom of speech and expression, what is the philosophy lies behind this particular, the fundamental right? See, this particular, the fundamental right, the philosophy is that the government or maybe executive, the government is giving a promise to the citizens of the given country that it will always secure to its citizens the liberty of thought and expression. The liberty of thought and expression is the very much core and fundamental for any individual growth. So what a person can think, and the expressing that what the expression of that particular thought process cannot be curbed in any manner if we want to encourage the given individual's growth in their personal capacity. Unless individuals grow, country can never grow. So from that point of view, suppressing or maybe creating barriers for the individuals, any individuals the thought process and the expressions is not generally, the warranted. So that is what is the promise that is made, that something is mentioned in the form of, the preamble, the liberty of thought and expression, right? So this is where in the Constitution 19(1)(a), that government is giving a promise to the citizens that we will not curb the citizens, the thought process, and even the expressions. Expressions can be in any form, through literature or through speech or maybe through art form. So through any form, the thought, an individual's thought process can be expressed. Okay. See, this particular, the thought process, when you are expressing this particular thought process of the individuals, do we have any restriction? Do we need to create any restriction? See, sometimes all the types of expressions, some types of expressions will create different kinds of, the hurdles for the government, for the smooth functioning or smooth provision of the governance and ruling to the people. So in that, that is by keeping in mind the larger objective of the government in securing different rights to the people of the country, right? Some of the individuals, the expressions can be curbed. So when you want to curb the restriction, the liberty, freedom of thought and expression for the individuals, what kind of restrictions can be created, can be imposed by the government? And these restrictions, we can call them as reasonable restriction. So as the name says, the reasonable restrictions means these, restriction looks very highly reasonable. It cannot be arbitrary. So unless these are reasonable, the given government cannot use this as a restriction to create barriers in putting limits on the given individual's thought process or the expression. But with respect to what are those reasonable restrictions, those reasonable restrictions also clearly mentioned in the Constitution in the 19th article, the subpart 2, the subprovision 2. There they specifically talks about the different reasonable restrictions which can be imposed by the government in the thought when we are curbing the given individual's thought process and expression. So this is what is the constitutional provision talks about. And when you see the evolution of this particular law, that is before independence, we had seen in the 1840, 1890, the Sedition Law was added in the IPC, in Indian Penal Code. But after independence, when the Indian policy makers were discussing about enacting an Indian Constitution, the Constituent Assembly specifically discussed on the issue called as the sedition, whether the sedition, the provision need to be inserted in the Constitution or not, because the sedition is there as part of, as a penal provision in the IPC. Whether we want to add this sedition as one of the restriction in creating, as a reasonable restriction in Article 19(2). But then the many of the people do, vehemently oppose it clearly. We cannot, the sedition cannot be made part of the Constitution, but let it be part of one of the penal provision in the IPC. So as part of the reasonable restrictions, sedition was one of the, sedition was not one of the provision. Okay, so that is what, the Constitution makers, what, they decided during the Constituent Assembly debates. But what happened after 19, the Constitution was adopted in 1950. In 1951, immediately the then government, first government, Nehru's government, was amended the Constitution, wherein they added, the extra restrictions which are called, which the has been already mentioned as a reasonable restriction. So those reasonable restrictions, clearly here he added the, the two more provisions to expand the scope of this reasonable restriction. So the expanding the scope of reasonable restrictions means you are curbing the individual's liberty of thought and expression. So that is what the Nehru government did in 1951. And again in 1974, the even more extra layers were added by the Indira Gandhi's government. That is, the government made it as a cognizable offense. What does it mean by a cognizable offense? The cognizable offense means generally these are offenses in which generally bail provision is not given by the for the given offense if it is not mentioned as a cognizable offense. So and another thing is, it is police also can arrest the people without any warrant. So like we generally see, if any police people want to arrest any individual, they need to they show the proof that they have a warrant issued by the magistrate or maybe the court, saying that that this is the specific reasons that we are arresting you, and we got even the permission from the judicial authority to arrest you. So that is something called as a warrant. So that is needed in the most of the cases. But some of the cases which they call it as the severe offenses. To those offenses, the government may add a provision called as without a warrant, the police can arrest the individuals. Okay, so this is how the sedition law has become even more stringent. Okay, by after 1974. Then, after independence, does this law was not contested before the courts? It was contested. So, see these two specific cases that happened in 1951 and in 1959. That is the cases that were filed before the two different high courts in two different times. In 1951, under the Punjab and Haryana High Court, and in 1959, Allahabad High Court. So these, when the cases were filed by different individuals saying that this provision is arbitrary, please do remove this provision from the IPC. That was the specific case that is filed before the courts. And when the cases were decided finally, the judgment was declared. The judgment declared by these two courts as these provisions are unconstitutional and they have no place to be part of the modern India post-independence as part of the IPC as one of the penal provision. Because in a democratic government, in a democracy, citizens do always have a right to, criticize the government and its government policies. Okay, so from that point of view, this sedition law that was enacted by the British people for their own, the selfish reasons, that they have no place in the modern India and post-independent India. So that is what the stand taken by the two different judgments that are given by the two different high courts and declared it as unconstitutional. So as soon as it is declared unconstitutional, the review petition was filed by the central government at the point of time in the Supreme Court. And in the Supreme Court in the 1962 has given the verdict wherein that that famous case called Kedarnath case. So in this Kedarnath case, the Supreme Court has given a judgment saying that the sedition law is not unconstitutional, which is constitutional, and it reversed the verdict of the two different high courts which were given the previous ruling as unconstitutional. That means the constitution here, when the Supreme Court has validated the given provision, section 124A in IPC. Okay, so that validation is generally called an upheld process. And here you can see the bench strength here is 5 judge. So anywhere in the Supreme Court, if you see 5 judge or more than 5 judge bench is sitting in the interpreting the given provision of the any law or maybe any provision mentioned in any law. The 5 judge bench, it represents the constitutional bench. Constitutional bench means they will see the constitutional bench will always go into the interpretation of the given constitutional provision. So interpretation, see, is the constitution explicitly do not mention everything that human civilization might be facing problems, but it merely mentions the gross provisions that that using that gross provision, the knowledgeable people like judiciary can interpret any law that may be passed by the government, any new law passed by the government, whether that law is in sync with the given constitutional provision or is it violating any constitutional provision. If it is violating or maybe in sync with the given constitutional provisions, sometimes it cannot be seen directly. That has to be interpreted. Okay, so that interpretation of the constitutional provisions to see whether the given law passed by the given parliament or maybe state legislature, whether it is the right or wrong, the Supreme Court will be constituting bench strength called as a minimum 5, and anything more than 5 or more than 5, the bench strength, here we can see that there is a heavy constitutional interpretation. And likewise here also they saw that in against to the 19(1)(a) that is mentioned as the right to freedom of speech and expression, under that whether the sedition law is violating any of the fundamental right that is given to the citizen. And here the constitutional bench decided that it is not violating the fundamental right, and there is no problem with the validity or a problem with the existence of this 124A in the IPC. But here the court has given clear guidelines that when you can use this section 124A to file a case against the any individual. And here they had given 7 specific guidelines. And what are those guidelines? We do not have to read them, but the here court did not they outrightly did not validate the given law. They validated the given law by giving a specific directions to the government, saying that you can book a case only when these specific the issues happen. So that is why the guidelines were given that how to use this sedition law to the government. And here it is also, you can see that mere the not all, you can see that not all speech with disaffection or hatred or maybe contempt against the state, the the not all, and but also only the speech likely to incite public order would not qualify the sedition. Generally the government, when it is booking cases, if anybody the giving speech, and because of this speech, if there is a public disorder means people started fighting with each other, or maybe people started attacking the government, or maybe government agencies, or maybe government people, it is because of the speech given by some individuals. So this is something lead to the public disorder. And by this public disorder created created because of the speech or maybe any expressions made by any individuals, does it qualify to the book a case under the section sedition law? Here merely that is also not sufficient. Okay, so that means here the application of this provision has been narrowed down further by this Kedarnath judgment, Kedarnath case judgment given by the Supreme Court. Okay, the next thing is whether any the what happened, what present the Supreme Court recently it has given judgment. So why it started giving the why it gave the judgment. So again here you can see in recently these the government started misusing this provision to book a lot of people, and in the name of sedition, that merely because they opposed the government and government policies. And because of this heavy misuse, some of the the learned people filed cases, PL by the public interest litigation in before the Supreme Court, requesting the Supreme Court that time has come that there is no place for this particular type of the regressive law in the post independence, that is after 75 years of the the independence in India. There is no place for these kind of laws wherein merely by opposing the government you can book a case under the sedition law, which is even more stringent. Okay, because the bail is also not available, bail cannot be given. And another thing is, without a warrant you can the book a individual. Okay, so that is why as the misuse of this law has become increased recently, some other people filed a case in the Supreme Court, and Supreme Court started the looking into whether this law is necessary at present in the present context. Okay, so first we see what is that how that misuse is happening. Simply go by the records that is mentioned by the officially maintained by the government itself. Okay, the National Crime Bureau records, it is officially maintained by the Ministry of Home Affairs, wherein you can see successively last 3 years. In 2018, 70 cases were filed in the name of sedition. Okay, but when it with respect to when the case is filed, how many people are finally getting convicted? Convicted means the proof that really they did something wrong as the provision that is mentioned in the section 124A. Okay, so conviction of filing a case is lies with the police or with the government, but conviction is the conviction of an individual is decided by the judiciary. Okay, so with respect to conviction, not a single individual out of the 7 cases that were filed in 2018 finally got convicted. That means these cases were not serious. And in 2019 you can see 93 cases were filed, but out of them how many were convicted? Only 2. So at least almost 100 cases were filed, only 2 people were convicted. You can see the success ratio is less than 2%. So less than 2% conviction rate means that given law is clearly being violated or misused by the executive. And you can see latest even during the COVID time also, the 2020, 73 cases were filed, but not even a single individual again got convicted. Okay. And you can see the highest number of cases that were filed is that in 15 cases were filed in the Manipur, that is highest, and in Assam, next 12, and the state, southern state, Karnataka 9, Uttar Pradesh 7. So likewise, you can see the state governments which are resorting to this provision section 124A is increased heavily. Okay. And this increase in, the increased heavily in especially in 2020. Okay. And this is something called, the misuse of the given provision. And you can see that here, this provision is being used by the police, government through the police, just merely to create some kind of fear, right? Are, in the among the individuals that do not speak anything in against to the government or government policies or government handling of any of the crises, especially the pandemic. That is why, in 2020, the government started filing so many cases, the central government, the state governments. And this is, the particular thing called as, misuse of the, so this is the proof that, the given law is clearly being misused. And second thing is, the what is the specific, the legally speaking, what legally it specifically talks about. The problem with the given law is it, it is defined poorly. It is not specifically mentioned what constitutes sedition. It clearly just mentions that disaffection, hatred towards the government, or maybe disturbing the public order. They only mentioned, three words, but those are not specific instances. So because lack of, the properly defining the given provision 124A, the state and maybe the police people is, the indiscriminately resorting to book the citizens under the given regressive citizens law. Okay. So that is, the problem with the that is why the number of cases were being filed by the authorities, but those are not withstanding the judicial interpretations, whether really this comes, the given act committed by the individual as they constitute the sedition or not. Okay. So let's take, the specific examples wherein judiciary interpreted the given case that is filed by the government, whether that particular seditious acts with really those constitutes the sedition. So first thing is, you can see the first example. There are so many numerous examples. I took only merely 3, but you can take, you can remember any of the examples. So you do not have to go through only these specific examples. First, there is the specific example of the Andhra Pradesh government. The Andhra Pradesh government, 2 news channels. So this is something going into, it is not, the case is not booked against the individuals, but booked against the news channels. Against 2 Telugu news channels, the Andhra Pradesh government booked them under the sedition law. So while finally deciding this particular case, Supreme Court, they clearly said that this is not something, the attracts the provision called as sedition. Okay, whatever done by these Telugu news channels in, in the airing process, it does not constitute sedition. So as part of it, in that given bench, the Supreme Court ruling, the present judge, Justice D.Y. Chandrachud, clearly remarked here, everything cannot be seditious. It is time that we have to define what is sedition and what is not a sedition. So what constitutes sedition, that is mentioned there, that is also poorly defined. And because of it, different government, different levels, they are booking the cases, different people, and even the, the media also being booked under it. So here showing, his frustration here, that so many cases are being filed recently. So everything cannot be seditious, and time has come that we have to define, right? Somebody has to, whether judiciary or maybe legislature or maybe executive, somebody has to define clearly what is sedition and what is not seditious acts. Okay, that is one, the one case wherein judiciary strike down the cases that was filed against these 2 newspapers, saying that the given acts committed by these 2 news channels does not attract the provision called as sedition law, that is section 124A. The second case is against the the former Chief Minister of J&K, that is Mr. Farooq Abdullah. So a PL was filed in the Supreme Court saying that, in 2019, Article 370, the Article 370, which gives special provision, special representation to the Jammu and Kashmir, that Article 370 was removed by the Parliament through an amendment to the Constitution in August 2019. So as soon as this provision was deleted from the Constitution, so many people did not like, especially the political people in the J&K, they did not like the idea of removing the special status to the J&K. So as part of it, somebody, some of the individuals filed a PAL alleging that, it's merely an allegation that, but there is no proof that he really talked about it, saying that Mr. Farooq Abdullah requested or sought the help of China and Pakistan in against to India, because India deleted the special status that was originally mentioned in the Constitution through Article 370, was removed by the Indian government. So no, I am it is mentioned as this particular person, gentleman, has requested the help of these two countries in against to India to restore again the Article 370. That was merely an allegation. So some of the interested people here directly filed the case in the Supreme Court. And this particular the petition also dismissed by the Supreme Court. And in that bench also, again, there is the same judge, Mr. D.Y. Chandrachud, was also there in the given bench. And here again he is expressed as the expression of views which is dissent and different from the opinion of the government cannot be termed as seditious. So the expression of views which is dissent means you are opposing the government and government policies. And anything that is, the given individual's opinion, if it is different from the government, we cannot merely treat it as a seditious. That is here specifically mentioned by one of the judge. And another famous case is during the farmers' protest, one of the teenager from the Bangalore, she has just only 22 years of age. Her name is Disha Ravi. So what she had done is she has created something called as a toolkit. The toolkit means here that generally, suppose if you see when want to do something with the given motorcycle, when you want to maybe take a cycle. So when you want to repair cycle, right? For different spare parts, to repair different parts of the cycle, we have different tools. So if you are having a box in book, in that box, if you are having all the tools which are, which can be used for the repair the given cycle, then that particular all the tools which is the housed in the given box, that is called as a toolkit. So toolkit is the tools that are used to solve a particular problem. So likewise here also, here the given the teenager, she got sympathized with the farmers' protest, okay, saying that farmers' cause is genuine, so that she wanted to help the given cause of farmer protest in her own way. So what she chose is to support that, she chose the medium called as social media. So in that social media, to create the awareness, to get the support for this farmers, these farmers' cause, what she did is she created different, the digital social, toolkits. So different tools that where how to promote a given, the given video, how to promote the given article, wherein to reach large number of people, so that we can get the support for the farmers. So likewise here, she has specifically, she was, the prepared a toolkit of the different social, digital tools, how to promote the digital, different content related to the farmers' concerns. Okay. So that toolkit was shared by not an, the Indian, she prepared it, but the the toolkit is reached to all the way to a climate activist from the Northern Europe, that is Greta Thunberg. She is also a teenager, and she is generally an activist in against to the climate change problem. Okay. So this this girl shared this toolkit prepared by the Disha Ravi, right, in support of the the farmers protest happening in India. So here the Delhi, the police cyber crime people filed a case and FIR and booked under so many provisions. They booked cases against the given individual Disha Ravi, One of the cases is seditious law, saying that, she conspired against the Indian government by, the making a pact with the foreign national. That is what is the allegation. So in this case, the case reached to the Delhi High Court. The Delhi High Court also clearly, they mentioned here that the government cannot put citizens behind bars simply because they choose to disagree with the state policies. Right here, whatever the toolkit she has prepared, it is not something, the creating any kind of enmity or maybe creating instability with the government. It is merely a tool she chose to support the farmers' protest. And in support of her, one international person came in support and she shared it. And this particular, the total process cannot be treated by the, the government as the policies in against to the state. Okay. And it is not creating any kind of the creating any public disorder. It does not create anything called as the disaffection among the people. So do not put, simply, the people simply behind the bars. And here the government, so the Delhi High Court squashed this FIR, which is filed against the Disha Ravi. Okay. Next, if you see how this seditious law, how it violates the constitution. The most important thing is the freedom of speech and expression, as we discussed in the beginning. It is the hallmark of the democracy, because the given individuals' speech and expression should not be curbed. It should be encouraged. If it is encouraged, the total country will be, the moving on to the next level of growth process. And unless the new ideas are encouraged, we the society and the individuals cannot progress. And progress is the norm of any human civilization. Okay, starting from the Harappan civilization in India to the present day, it is continuous evolution and progress. And the progress and evolution can only happen if you are giving freedom to the individuals in the form of speech and expression. Apart from other fundamental right, this is one of the fundamental right that is very much core to the individual's progress. And in a democracy, always the citizens should participate in the debates. Okay, the debate is, in the debate, somebody, those who are supporting the given idea, somebody, there are always some people, those who are opposing the idea. Okay, so that is happens in the society. Same thing with the government also. A democratically elected government, whatever it is doing, it does not, it cannot ask all the people to support what government is doing, because there are always some people who may disagree with the government stand, or maybe what government is, what are different government policies are. And that opposition is very much required, because in the parliament also you can see there are always two sides. One is government, there is always opposition. The opposition is, the always here keeping a tab on what government is doing, criticizing the government policies, and through criticism here it is giving you the other view or shortcomings in what government is doing, or what are the shortcomings in the given law. So through these criticisms, through these debates, any law will be improvised, and it will help the lawmakers, and it will also help the individuals, those are concerned with the given provision, those are executing the given law. So here the sedition law, which is ambiguously defined or poorly defined, which is being used by the executive. That means the government to book the people, the discriminately to regulate the public opinion. Regulation of public opinion means if anybody is opposing the government, book a case called a sedition. If anybody is supporting, then supporting the government's narrative, don't take any action against them. Right? So this is not something that is a hallmark of the democracy. In democracy, both sides should be continuously thriving. Those are supporting the government policies, those are opposing the government policies. Okay. Next, the another thing is, if you see the famous case here, in the 2020, one of the journalists working for the NDTV, he criticized the government response to COVID-19, especially the second wave. So as he prepared so many documentaries or videos and interviews, and they started airing in this channel, the government booked him under the sedition law, saying that government is taking this is a time that do not create anything called as the negative view about what government is doing to tackle the COVID-19 crisis, because people are in the at present the situation is the pandemic. Everybody is confused, everybody needs confidence rather than creating disaffection or maybe towards the government. So towards that, the government booked him under the sedition law. And here you can see journalist, and even in the previous case also Andhra Pradesh government media houses here is booked under sedition law. And this you can see the extreme form. Individuals maybe can book, but you can see the freedom of press and media is very, is also a fundamental right. And media is, always, the mentioned as the fourth organ of the state. So why it is called a fourth organ of the state? Because the media is always getting the, the having more connection with the people, and getting to know what is the people's opinion about different policies, and they are being represented through the print media and also through the news media. And if that media, if you are punishing them with this kind of seditious law, then you can see that, the democracy is going in a reverse direction rather than in the progressive manner. Okay, so this is, the cases that is coming. And here also the Supreme Court and the Delhi High Court here, the the warned the police people that do not book everyone under the sedition, and whatever Mr. Vinod Dua had done, it is not seditious. Okay, so this is something, the what the seditious law and how it violates the constitution and how it is being misused by the government. And when it comes to what is the view of the law commission, the law commission is something like, as we know, the finance commission or maybe the election commission. Likewise, the law commission is a committees that are formed by the law ministry regularly. It is not, always there is no law commission. Regularly, whenever the government feel that there is something that, new views or new interpretations is needed for a different laws or maybe different constitutional provisions, a law commission will be formed by the law ministry. And the law commission is generally headed, always headed by retired judge, Supreme Court judge, or maybe CJS of the high courts. Okay, so that means the people, those who have the knowledge in the legal sphere, they are actually heading this particular commission. So in 2018, it submitted one of the report to the government, and in that report, they fortunately talked about the validity of the law, the provision that is for Section 124A of IPC. And here, this law commission also supported that, we do not want to remove this provision. Let it be there. Okay, it must remain. So you can see that this particular provision must remain in the IPC. But however, it should be criticized that whether the word could be substituted suitably with another, because the sedition, it talks about it is, it says that the given individuals, the whatever they commit, it looks like the extreme form of crime, but this is not something. So we, the particular provision should be there called as 124A, but whether we can use word called as sedition or not, whether we have to replace with any other word, that we have to discuss, right? Another thing is right to, when you have the right to freedom of speech and expression, it means that you also have the right to offend. Right to offend means that you can offend the government, you can offend the other people, but is that right absolute? It is not. Generally, obviously, you do not have, the complete right to offend other person, but up to a point you can offend the other person, you can offend the government. But whether merely that, offending other person is qualifies as hate speech. Hate speech means the speech, because of the given speech, the given, the people, those who, got motivated because of the speech, and they started hating government or maybe government policies, so that speech is called a hate speech. So merely offending the government, right, scolding the government or maybe government missionaries like ministers or maybe prime minister, merely, scolding them will be, will be qualified as hate speech. That also needs to be scrutinized. Okay, so finally here they talked about here this, particular provision can only be, the invoked only wherein you can see that intention, it is not what they are doing, but what is the intention behind the given individuals, what they are doing. So if their real intention is to disturb the public order, or maybe through overthrow the government. Overthrowing government is not something the right that is available to the individuals. Okay, there are some constitutional provisions how to remove the government if it is not acting according to the constitution. Okay, but apart from that, no individuals or group of individuals can take or maybe can resort to overthrowing the government, or with violence or maybe through any illegal means. Okay, so what is more important is see the intention. And if the intention is really of this disturbing the public disorder, or maybe disturbing public order, or maybe through overthrow with the government, then only invoke this provision and book the people under this seditious law. That is an advice. Okay, merely law commission, suggestions are only suggestions. These are not something binding on the government. So through this, it also urges that there should be a balance between what constitutes sedition and what are the rights of the individuals, fundamental right, that is right to freedom of speech and expression, because the installing the given safeguard against the misuse of the seditious law is the need of the hour, because this particular law is being misused by the government agencies at various level. Okay, so that is what is advice given by the law commission. And when you see what is the seditious laws with in the other countries, if you see the origin of the seditious law in India is by the British people, right? British rulers inserted the provision. So whether the provision was there at all in the British, UK at present. So there was that particular section, what constitutes sedition, like in India, there was also the equivalent provision in the British laws. But in the 2009, what they did is finally, 2009, the case was filed, and in 2012, finally, the UK government finally removed that provision which is constituted as sedition. So saying that again, anything when you are talking about the against the government is not seditious. So the law which talks about the seditious, the provision that is talks about the sedition law was removed from the UK, the policies. And next thing is with United States. In United States, still there is something called as a seditious provision. So, but they do rarely use it in the specific cases where any individual or maybe individual group of individuals, they are creating disaffection or maybe to take over the government or overthrow the government. During specific cases, they are specifically applying this law. Otherwise, there is this provision is there in the UK, US statutes. And you can see in Australia, the seditious law was the deleted or repealed in 2010. And same thing with the Singapore also removed it. So you can see all over the world, the countries' governments are recognizing as sedition has no place in the modern world. Okay, especially in the democratic countries. Okay, so if you have the seditious law, you are clearly creating barriers to the individual's growth process and growth interlinked to the thought process and the expression. Okay, and what is the present case? That is so case reached to the Supreme Court, and Supreme Court, while it is discussing about the hearing the arguments in support and in oppose of the given section 124A provision, it has asked the central government also to submit its views, because at the end government is the agency which has to accept with whether there is a need to change the provision or need to change anything that is mentioned in the constitution or maybe any law. So here initially Supreme Court, the central government supported or defended the given provision, saying that isolated incidents of misuse merely necessitate the removal of the provision itself. We need that provision as a safeguard, that because there are some people who might be really really creating public disorder or maybe disaffection towards the government. So during that time, we should have this kind of the provisions to penalize the given individuals. Okay, but here as government, Supreme Court talking about, there is a clear misuse of the given law, especially in last 3 years. You can see number of cases filed and number of convictions. So as you can see that there is more misuse rather than being used for the specific cause. Okay, why this particular provision is mentioned in the IPC. So here the government stand initially was isolated incidents of misuse does not necessitate the removal of the provision itself. That is what is the government initial stand taken by the government. But later on, this central government changed its stand, saying that yes, we do also feel that there is a problem with this provision, that it is being misused. So give us time that we will review it. We will go through, because reviewing is, this is something a decision not taken by some individuals. We need to consult with the multiple people. We need to take the opinion of the multiple stakeholders. And for all these things, the review process, it will take time. And obviously, law making is the domain of the parliament, right? So when it is domain of the parliament, then we will propose the necessary, after reviewing, whatever changes that we want to make to the section 124A, we will do it through parliament. Okay, that is what is, you know, the stand or maybe the view represented by the central government in the Supreme Court. And as soon as, you know, the view has heard by the Supreme Court, then immediately directed all the, you know, central government and all the states, do not book anyone under any new, you know, do not book any new case under section 124A till you complete the review process. Till you complete the review process, do not book any new case. What about the cases that are already booked? So cases that are booked already, which are maybe at any stage, which are maybe in the trial stage or appeal stage or proceeding stage, all those, you know, the cases will be stopped. And these people can approach the respective courts to get respite. Respite means when this provision is not in application, you cannot book anyone on the particular case. If anyone already booked, now you can clearly get a bail and come out of the given jail. Okay, so that is what is, you know, the directive that is given by the Supreme Court. Okay, so this is the end of this particular topic.